obviously I'm not going to be able to cover what's a very complicated area and very expansive, so I wanted to give you a few resources that you could look at to cover all these issues, and also in case I make a mistake and I got some of this wrong, you can look there and find out what the real law is. One is probably one of the work-life law is worklifelaw.org. Many of you may know Cynthia Calvert and Joan Williams, who have done a lot of work in this area. Their website is fantastic on this. They have among other things, a litigation report that they do. They did one in 2016, and for those of you who are looking at these cases or thinking about taking these cases, just from a nuts and bolts perspective, and paying the mortgage and all that, these cases win at trial at a much higher rate than other kinds of discrimination cases. I think for pregnancy it was upwards of 60%. There have been some impressive jury verdicts. According to the study, there were less settlements, and they speculated, which is probably true, that employers don't often understand caregiver discrimination law, and so they don't correctly evaluate the case, and so don't settle it. But juries sure do, and they don't like them. So that's a good thing to check out. Work-life law also has, if you're working with OBGYNs and trying to get, which as you were just discussing, getting the correct letters. As Joan Williams says, you don't want your doctor writing a "please fire me" letter. Even though they're trying to help, but they don't know what to do. You can go state by state, and they have sample letters in there if you're able to work with the doctor. That's very helpful. Of course, the National Women's Law Center's website is very good on these issues. I see Laura Brown in the audience. First Shift is a great organization, particularly if you have somebody come to your office who is lower income, who is still at work. There may not be a lot of damages that make sense from an economic perspective to bring the case. First Shift does a great job of working with those kinds of plaintiffs. Better Balance, and a lot of this is in the material. Better Balance, a New York organization, also has a terrific website that focuses on a lot of these issues. And both the National Women's Law Center and Work-Life Law have attorney networks that you can apply to be in to attorney referral networks. Work-Life Law has a great Facebook page that's pretty active, so I highly recommend that you check those guys out. One of the areas that I'm going to be focusing on just briefly is the interplay between the ADA Association Clause and the FMLA. A lot of caregiver discrimination is covered under these two statutes and the interplay in between them. A good resource for FMLA, which is a really complicated statute, is a blog called FMLA Insights. It's actually written from the employer side, but he has a lot of really good information about the intricacies of the FMLA. And second, before I get into the substantive areas, are just some of the nuts and bolts for how to deal with these cases. Any kind of caregiver, or I would say pregnancy discrimination case, if I can get into DC, that's what I'm trying to do. The DC Human Rights Act is much more expansive, and it also applies to things that occur outside of DC. So you may have a plaintiff that has never, they work in, let's say, in Arlington or somewhere in Maryland, but HR is in DC and the decision is made in DC, you can get shoehorned under the DC Human Rights Act. I would also look at any local ordinances, particularly if you are in Howard County or in Montgomery County. If you have the misfortune to be in Virginia, there's not much to work with there, but those two ordinances are also very expansive, and like the DC Human Rights Act, have some real advantages. Most don't require an administrative exhaustion. You can go straight to court if you want. Longer statutes of limitations, no caps. And for the DC Human Rights Act, a really broad application of the law, particularly for caregivers. So, if you've got a transgender person that you're working with, if you've got somebody that falls outside the area of one of these other statutes, either because of the size of the employer or because of the disability, there's a good chance it's kind of covered under the DC Human Rights Act. So I would take a look at those first when you're dealing with any of these issues, and see if you can get in one of those jurisdictions, because it tends to be a lot friendlier. So let's talk about, and I've got a slide deck, but it was way too ambitious. I'm not sure how I can even work it here. I'll just go through a few here, but looking at the ADA, particularly the association clause, this is a sleeper that some people, including employers, miss. The ADA protects people who are from discrimination because they are associated with somebody that's covered under the ADA. Typically, this is a family member. One thing to remember about this is that under the association clause, the plaintiff is not entitled to an accommodation. So you can't, leave work early because you need to go care for a spouse who is sick at home. However, it does disallow discrimination on that basis. And we see this come up in three different areas. One, when there's an extreme cost, usually a health insurance cost associated with the person who's the covered person, the family member who's at home. We see it it seems less now, but some that when there is a concern, particularly for HIV cases, that the employee is going to be infected by the same disease and therefore it's going to be affected at work. And then finally, where we see this a lot in caregiver discrimination issues generally, the belief that the employee is going to be distracted by the fact that they've got somebody who's home who's disabled and therefore won't be committed 100% at work. So those are the three areas that we see the association clause come up in. Another statute that is implicated when you have these situations is the Fmla. The Fmla it's a powerful statute in some ways, but it has some restrictions in that it only applies to employers that have 50 or more employees within a 75-mile radius, and generally the person has to have been there for a year full time before they're even covered by it. I can't tell you how many times we've had somebody call us and it sounds like a really good FMLA case, but you find out that they were only there 8 months. There were some shy of a year, and so they're not covered. A couple of things to look at with the FMLA, some sleeper issues are estoppel cases, okay? So where HR gets it wrong and tells somebody that they are covered under FMLA when in fact they are not. The employer can be estopped from relying on the exclusions to the FMLA to say that it doesn't apply. Also, when the leave period will take place, so if they're right on the bubble, there's, let's say they're at 11 months, they'll be covered within a year. The leave is going to take place when they would be eligible. So for example, in a pregnancy situation, then they would be covered at the time that they take leave. And if they're fired before that, you could have an FMLA interference or retaliation case. Now, one that is not in your materials. Yeah, it's not going to be your materials I provide later that's worth a read that goes to the interplay between FMLA and ADA. I'm not even going to try to pronounce this plaintiff's name. It's GRAZIADO versus the Culinary Institute. The site is 817 F3rd 2016. I think we can send this out. I can send this out later. It's an interesting case because it's a Second Circuit case, and it establishes an important point with the FMLA, and that you have, unlike the ADA in Title VII, you have individual liability under the FMLA. You can have individual liability. And why does that matter? Well, it matters because, hey, it's nice to really kind of go after the bad actor and name them in the complaint. It could also theoretically be possible, not that I would ever do such a thing, that if you were in a jurisdiction in which, let's say, you had a judge that you knew you were going to be dead in the water no matter what if you ended up before this judge, you could file under one party. If you did draw that judge, then you could amend to the other one. And then if you did draw that judge, you could dismiss and then refile. I'm not saying I would do that, or I may be recommending that, but such would be possible with an individual liability claim. So under the Second Circuit case, the interesting thing about it was the interplay between the FMLA and the ADA. This poor woman, her son was a diabetic, and she took he was hospitalized for this care. She took time off FMLA for that time. As soon as she came back, her younger son was injured and broke his leg and required hospitalization. So she had to take more time off under the FMLA. She brought, essentially what happened was she was eventually fired, but it was because they claimed she abandoned her job, but it's really, as the court even describes it, an excruciating review of the record, but the emails back and forth between this plaintiff and the employer where she's trying to comply with FMLA. She's saying, what paperwork do you need? Is there anything you're missing? And they were sending back emails saying, yeah, you're missing some stuff. Here's some stuff in the Department of Labor. You figure it out. And she kept emailing them. They would not email her back. She hired an attorney. The attorney was interacting. She wanted to come back. She's like, I want to come back to work. And they said, well, you're not clear. You haven't given us the correct information. Her parade of horribles, her attorney's in a motorcycle accident and doesn't respond to some correspondence, and they fire her for job abandonment, even though she was trying to come back and saying, I'm willing to come back. And the court pretty quickly pokes holes in their argument that she abandoned the job. They're like, look, we got all these emails here that you're not responding to her, and moreover, it's not good enough just to say, here's some guidance from DOL, figure out what we need and give it to us. But the interesting thing about this case was she also brought a claim under the ADA Association Clause, and the court said she did prevail under the FMLA retaliation and interference claim, or at least survived summary judgment. The court said that the ADA Association Clause did not apply, and there's some good language in the case about, and they cite to other cases about the situations in which the Association Clause does apply. But her argument was that the employer was concerned that she was going to be distracted because her son had a long-term disability, the diabetes, that she was going to have to continually monitor. And the court said, no, there's no evidence. Yeah, they really stepped in it with regard to the FMLA, but there's no evidence here that they had a concern that you were going to be distracted when you got back to work. So she did lose under the ADA claim. And then just quickly, another case, one of the issues under caregiver. So in any of the caregiver situations, you're looking under your ADA, your FMLA. Of course, if you can get under the DCHRA, all the better, or some local statute. But another issue that is increasingly becoming common are elder care cases, and these are often under the FMLA. I'll just give you a cite real quick to a North Carolina case. It's 314 CV 369. It's a 2015 case. It's Snow versus Vanguard is the name. It's a good case. It's pretty short, but about elder care. She took time off to care for elderly parents. She tried to apply to get a promotion. The employer, you couldn't wish for a better case on the facts. The employer, when she took the FMLA leave, went to HR and said she should be marked as needs improvement because she wasn't going to be sufficiently committed to the workplace. And then when she applied for the promotion, asked her about her FMLA leave. And then she didn't get the promotion, and the court said, okay, that's good enough for me. So that's kind of an FMLA elder care sort of situation. But there's a lot more for caregiver discrimination. We obviously didn't cover sex-based stereotyping discrimination, which is another whole category. I urge you to check out some of those resources. There was some really good stuff in there.